Sir, item number 2.
I am for the respondents, my lord. Your lordship would kindly remember that on the last occasion, last week, I have also filed a writ petition challenging the same order. I have mentioned that to be tagged with, but that matter has not come.
What is the number of the case?
WPCT 132, and this one is WPCT 56.
Number 3. IAP for the petitioner is not there, not today. It is coming for the first time. All right, not today. Yes. Now 4. Lord, in this matter, Lord, Miss Amrita Pandey is there, Lord. Just she is coming, Lord. I'm praying for Lord Pastor.
Lord, I was sticking, my lord, 1 week accommodation, my lord.
Oh.
My lord, because my lord, Mr. Orgho Chakraborty, my lord, who is appearing, my lord, his my lord, uncle is not well, my lord. That is why, my lord, I was seeking 1 week accommodations.
On prayer, mate. Now 5.
The appellant. You will kindly turn to page 191. It's the impugned order, lordship. That matter, lordship, where the petitioner had initially resigned and thereafter had changed his resignation to voluntary retirement after 4 years.
You've gone through the last order. Not today. Item 6.
In item 6, Mr. S.K. Dotto is the arguing counsel in this matter. He's instructed me to seek an adjournment today, my lord. My lord, may it be kept after 4th of July. He won't be available during this period.
You are on record.
No, my lord. I'm not on record.
As prayed based on Item 7.
In this matter, Mr. Rudrajyoti Varsity is leading us, but he has a spine surgery. He will be joining the court on Monday. Kindly fix it on 3rd or 4th July. He will do the matter.
Let it not today. You mentioned on Monday.
But kindly fix it on Tuesday. He will be there. Fixed it on Tuesday. He will be there and do the matter. He's coming on 28th.
On
28th Saturday, he's coming back.
when is he coming back?
On this Saturday.
Then Monday it can be done. What is the problem?
And fix it on
See, not today. Yes.
kindly fix it on Tuesday.
No, ask him to come. Madam 8.
Number 8, my lord, I am for the petitioner, led by Mr. Uday Sankar Bhattacharya, my lord, he is on leg, my lord. On earlier occasion, my lord, we have already made our submission, my lord. The respondent was supposed to give.
Yes, in which paragraph of the tribunal's order the reason has been assigned for allowing the claim? Yes,
My lord,
you are beneficiary of the order. Therefore, we are. Where the tribunal, which paragraph
my lord,
the tribunal has found the intent? 13 onwards. 13 onwards is just taking note of apex court judgments. Where is the consideration of your claim?
The above now coming, last paragraph was mentioned for all the reasons herein above.
So where is that reason? That is what we are asking you. This order is under challenge.
My lord.
We are trying to see whether the tribunal has assigned any reason for conclusion of allowing the same.
My
That
lord,
is what
on
we
the
are asking.
basis of these aforesaid reasons, my lord, that paragraph onward, that is the, on the basis of,
That is all.
and that is the reasons that we mentioned.
All right.
And my lord, in this,
So you are not able to point out any reason
My-
assigned by the tribunal.
on the basis of this judgment, my lord, this judgment, that I cannot improve this judgment, my lord.
Therefore, we are asking you. You cannot improve it. So therefore, we are asking you, where is the reason assigned by the tribunal?
My lord, that is the reasons, my lordship.
For all the reasons above.
The basis of
Very
the-
good. That will consider.
My lord, kindly allow me, my lord.
Yes.
In this case, my lord, rule 38 had
Where is the consideration by the tribunal? We are asking you. Whether 38, 17, whatever it is. 19 circular, prior to 19, what is the situation? Where is the consideration?
My lord, in the severance.
See, you were enrolled in March 2001. You were after enrollment immediately within few months, you were found to be having tremors. In July, you were already out. You were there for about 4 months.
5 months.
You didn't do anything for about 18 years. After 19 years, you approached the tribunal. So we are trying to see how the tribunal, what has
Here,
weighed in the
my
mind of
lord,
the tribunal.
Commissions, lordship, in this case, my lord, the first point is, lordship, in the case of the pension regulations, Army 197 and 198 of the pension regulations, that is defined this definition of invalid pension. After that, my lord,
Where is the consideration, madam? How do you support the tribunal's order? That is the issue. We are not here to hear the matter.
my lord,
We are here to see whether the tribunal has acted in accordance with law, has considered the case, has assigned any reasons or not. That is the
reason
scope of judicial review.
in the foregoing paragraphs, my lord,
All
because
right. So there, that you have already said. That you have already said for all the reasons stated above.
my lordship, subject to lordship, kind correction. Well, now this after my lord P.S. Thomas judgment, now it is a covered case, my lord.
Where the tribunal has recorded this finding.
But that's mentioned in paragraph 13 onwards, my lord, because
Just point out where it has recorded the finding. That for these reasons, your case is covered by which provision?
provisions, my lord.
So that is why if you are saying that is all, then there is nothing else.
Well, that has been mentioned on the basis of the
That
hearing.
we have missed, we couldn't find. Therefore, we are asking you repeatedly. In spite of going through.
Satisfy your lordship, because as per para 21 and 22, therefore in view of the legal position also it cannot be said that the way is time barred. We therefore find the present a fit case where the delay occurred in filing the original application deserves to be condoned. In view of the same stand satisfactorily explained, the same is accordingly ordered to be condoned. For all the reasons herein above, this application succeeds and the same is accordingly allowed. My lord, on the same issues, my lord, on the same self-observations has been made by the lordship, the Honorable Punjab High Court, a very recent judgment on the same issues. Regarding this, now they mention on the after the P.A. Thomas judgment, now this invalid pension, the length of service is not at all is a consideration part now. Lord, that has been mentioned here, lordship, in this judgment.
Yes.
Lordship, may I allow lordship to produce this judgment, madam?
Yes.
Before that, my lord, this is the P.A. Thomas judgment, my lord, though that judgment.
See, the point is, in the tribunal's order, there is no consideration of the disability being suffered by you. There is no consideration as to why the finding of the board that it is not attributable will not apply is incorrect. No, we are not on this that for 5 months. We are on what is the reason assigned by the tribunal.
My lord, my submission is because lordship now this several orders. are already
Therefore,
passed.
anyone who comes has to be given. That then show us from the order then.
From the order,
Yes.
mentioned lordship kindly allow, people lordship kindly.
We are allowing, we are repeatedly asking you, you are not showing.
Para 13 onwards, my lord, I cannot improve
We
this
could
judgment.
not find where
My
the
lord, that is the
consideration.
law, my lord, that is the law has been.
So that law applies in the case of this petitioner, where the tribunal has held that the law applies in the case of this petitioner for these and these reasons. Where is that? Show us.
My lord,
Nobody is
that is
disputing
what-
the law. They are also not disputing the law. We are trying to see what the tribunal has
My
done.
lord, my humble submission before the lordship, my lord, they disputing the law, my lord, they mentioned now the CCS pension rules cannot be applicable. Their first contention, their second contention is.
What is, you have come to the tribunal, they have not come to the tribunal. Therefore, you have come to the tribunal making a claim on what basis it has been allowed. We are asking you.
My lord,
You say 13 onwards, 22 for all the reasons stated.
if the
So we will
observation-
consider that. We will consider that. Then there is nothing.
Now, lordship, on the base, lordship, what is the, my
There is
understanding?
nothing.
And this is what is my understanding is that this case, after this several judgments, lordship, only they only quote these judgments on the basis of this, the several others are given on the same issues. Like it is not that lordship, because they you have to be given that present petition, present applicant. This is not the case, madam, because his case is totally covered in other cases in similar situations. Because lordship, P.A. Thomas,
Where is that finding that this case is similarly situated to anyone? Show us.
well, for the above reasons, lordship.
Madam, please.
Things also, I cannot improve the.
Therefore, there's nothing. Therefore, we are saying there is nothing.
Well, because
Neither his entitlement has been considered, neither the disability suffered by him is considered, neither the cause has been considered, neither it has been considered that it is similar to anyone. Supreme Court says this for all the reasons stated above. Unique order.
well, only one thing, my lord, if that be so, well, in the previous paragraph,
Let
my
the
lord,
tribunal reconsider. You go back. You make out your case. We are not stopping. There is no finding on basis of anything. We don't know whether these judgments will inure to your benefit or not. Because the tribunal's order is.
as your lordship, then lordship give me that, so.
Yes, you go back. Yes.
There is no explanation in respect of delay of 16 years.
So it will all be considered.
My lord, my lord.
The
Item number 5, Lordship. Your Lordship was pleased
Call the
to,
next case.
Your Lordship was pleased to make it not
Call the
today,
next
Lordship.
case.
Monday, I have some difficulty, Lordship.
Call
Will
the
kindly
next
take it on
case.
Tuesday.
On a 9 minute, I am for the petitioner, my lord.
And for the respondent.
During the service tenure of the respondent, private respondent, that is the applicant before the tribunal, my lord, the manager of the Oriental Bank of Commerce, my lord, lodged one criminal complaint before the, my lord, the Salt Lake PS.
The manager lodged the complaint
Yes. Manager of the Oriental Bank of Commerce, my lord. They have lodged complaint before the Salt Lake police station. And accordingly, my lord,
against the applicant.
against the applicant. And my lord,
He
according
was working as,
as a, my lord, the railway employee,
Technical.
the bank has lodged a complaint against the railway employee.
against the railway.
All right, yes.
And accordingly, my lord, the Salt Lake PS, my lord, started a criminal case, my lord, case number 55, dated 5/6/2006, under section 467, 468, 471, 419, 420, and 120B of the Indian Penal Code, my lord. And thereafter, my lord, during the pendency of this criminal case, the petitioner, that applicant was superannuated. And my lord, everything was, my lord, the released. But my lord, only the gratuity portion was, my lord, withheld due to that criminal case, pendency of the criminal case. And my lord, according to the railway pension rule, section 10C, my lord, that power has been given to the authority. If there is any criminal case, that is to, they can, my lord, thereafter also that amount has been, all gratuity amount also released. My lord, now thereafter they have
Released.
released. And ultimately, my lord, the tribunal was directed to pay the interest.
If it's already released, then why the tribunal
That
was?
due to the delay, that withholding portion, my lord, that time, my lord. And my lord, my humble and respectful submission, my lord, in the two ways. My lord, according to the
No, you said that the amount was released. If the amount was already released, why they were required to go to
for
the
interest,
interest?
for interest. And my lord, the
So the issue has to be seen whether it is for any administrative lapse or not. Withholding.
my lord, two things is to be considered, my lord. First,
Yes.
my lord, according to the L. Chandrakumar's judgment, my lord, that clarify that relying on that judgment very recently, my lord, our honorable division bench had passed the one order, Bachchan Pandey's matter, that the initially that decision was the single member of the administrative member has no jurisdiction to finally decide that matter. Thereafter, my lord, that has been clarified, and this honorable division bench was decided if there is any complicated question of law is there, or there is any interpretation of the rules is there. In that case, matter is to be decided by the division bench of the honorable tribunal. But my lord, in the
Yes.
that case, my lord, my specific case was that the railway pension rules was involved. There is, my lord, in the judgment, no such whispering was there. And my lord, in the very peculiar manner, 2-3 unreported judgment was relied in the impugned order, my lord. And the tribunal hold that factually those judgment has no reference in this matter. Even then, they have relied on the basis of the decision directed to pay the interest. My lord, for a moment, my lord, kindly see.
When did he retire? Attain the age of superannuation.
On the date of superannuation, 13th June 2016.
And when did you release the gratuity amount?
No, no, no,
September
2000
2017.
No, my lord, this is wrong. 2023, my lord. 23 or 24.
You released it within 1 year.
Yes, my lord.
And for 1 year interest, you are fighting.
Yes, my lord. My
What is the date on which you released it?
In 2023, my lord.
23.
My lord.
He is saying 17.
My lord, this is wrong sum. During the pendency of the OA application,
These are the relevant dates. You should be ready with these dates. Very unfortunate. date of retirement, date of release. These are the two relevant dates. Even that you are not able to tell the court. You are arguing the pension rules and how it applies.
My lord, date of retirement is 13 June 26.
And what is the date on which you released it, sir?
My lord, may I submit? My lord, the FIR lodged against me in 2010.
Sir, can you give us the date on which it was released?
Released on 2023, my lord.
That is the date. 23 is the date.
My lord, may I come in? My lord? During the pendency.
Give us the date, please. You are beneficiary, you don't know. He is liable to pay, he doesn't know.
Breakup of this payment was given to me on 2nd March 2023, my lord.
You will say everything, but you will not say what the court is asking you. Both of you are fighting over this and you don't know, neither of you know what is the date on which the amount has been paid. For what period interest has been levied, even that nobody knows.
My lord, just, my lord. In 9th January 2003, the respondent was directed to furnish the breakup.
It was paid during pendency of the OA.
My lord. In the interim direction of the OA, learned tribunal, that the ratio what I relied, what should submit the ratio of this judgment to the direct to the authority, and authority considered this ratio and directed me to come their office. White letter dated, my lord, I am annexing this letter.
Please, sir, we are trying to look for one fact. We are not hearing you right. There is one reference to 9/1/23. That is a daily order wherein they were directed to furnish the breakup of the amount paid. So it must have been paid before 9/1/23.
Just after that, they directed to give the breakup. My lord, I got it, my lord. In 25th November 2022, my lord. Thank you.
Should be somewhere around this time because in January it is.
My lord,
So that the court, the tribunal has said that
25th
to furnish the breakup
November.
of the amount.
My lord, 25th November 2022, my lord.
About more than 6 years. Yes.
Now I am before your lordship.
Where is the provision? Let's see. That is all that has to be seen.
See the rule 10 and sub rule C, my lord, particularly. The provisional pension for departmental or judicial proceedings may be pending. In respect of a railway servant referred in sub rule 3 of rule 9, the accounts officer shall authorize the provisional pension not exceeding the maximum pension which would have been admissible on the basis of qualifying service up to the date of retirement of the railway servant, and if he was under suspension on the date of retirement up to the date of immediate proceedings, the date on which he was placed under suspension, the provisional pension shall be authorized by the account officer during the period commencing from the date of retirement up to including the date on which, after the conclusion of departmental or judicial proceedings, final orders are passed by the competent authority. C. No gratuity shall be paid to the railway servant until the conclusion of the departmental or judicial proceedings and issue of final orders thereon, provided that where the departmental proceedings have been instituted under the provision of the Railway Servant Discipline Appendix 1968 for imposing any other penalty specified in clause 1, 2, 3, and 4 of Rule 6 of the said rules, the payment of the gratuity shall be authorized to be paid to the railway servant. That point was very specifically taken.
Yes.
Kindly see the page 21. That was the reply filed before the tribunal.
81.
Reply starts from page 78. I am relying on the paragraph E, page 81. The applicant superannuated from his service on 13/6/2016. At the time of superannuation, he has been sanctioned with the provisional pension, PF amount, GIS, and leave encashment. Only gratuity has been withheld by the competent authority. Due to the said pending criminal case, competent authority have decided in according to the Railway Service Pension Rules 1993. And my lord, in the impugned judgments, My lord, there was that,
So for every criminal case, the gratuity can be withheld.
my lord, that rule 10C, my lord,
Rule 10C has to be read in isolation.
that power has been given to the railway. and
That power has been given in what circumstance? You will read just the power.
My lord, that no gratuity shall be paid to the
In
railway
what circumstance, sir?
until
The rule
conclusion
10
of the-
starts with some, it starts somewhere. It does not go directly to C. So can you read C directly without reading the first paragraph in rule 10? What does it say?
My lord, that judicial proceeding, if there is any pendency of the criminal,
Please read 10(1)(a).
in respect of a railway servant referred to in sub-rule 3 of rule 9,
Yes.
the account officer shall authorize
Those 3(9) only in that circumstance.
the
Now what is
provisional
3(9)?
means the
Come to
pro-
3(9).
the account officer.
Does it talk about any, or it has to be in relation to the work performed by him? That is the only issue.
My lord, that at the top, my lord, rule 9(3), my lord,
Yes.
in case of a railway servant who has retired,
No, sir. Again, the problem
Bit
is
of
you just want to
superannuation.
read one line and you form an opinion, or you will pass the order based on that one line, whether it can be done like this. If they have committed an error, then you should be doing the same thing.
my lord, admittedly here.
No, admittedly, read the first paragraph. Read the first paragraph of 9.
Criminal cases.
Please read.
The president reserved to himself the right of withholding the withdrawing of a pension or gratuity or both, either in full or in part, whether permanently or for a specified period, and or ordering recovery from a pension or gratuity of the whole or part of any
Any pecuniary loss caused to the
railway,
or if
and
any
if
departmental
any
or
departmental
judicial
or judicial proceedings,
is found guilty.
the petitioner is found guilty
Yes.
of grave misconduct or
During period of
negligence during
service.
the period of his service.
And you are
including
saying
the
any
service
criminal
rendered
proceeding, it
upon
can be done.
re-employment after retirement.
And you are saying in any criminal proceeding, it can be done. 9(3) has to be read in this context. And therefore 10(c) has to be read in this context. From where you are getting that for every criminal proceeding, it can be done.
My lord, for a moment, kindly see the 9(3), my lord. In case of a railway servant who has retired out attaining the age of superannuation or otherwise, and against whom the departmental or judicial proceedings are instituted, or where departmental proceedings are continued under sub-rule 2, a provisional pension as provided in sub-rule 96 shall be sanctioned. My lord, admittedly, in this, no departmental proceedings was pending there, or was in.
Admittedly, no judicial proceeding regarding his service. Admittedly. Is there any dispute on this fact?
My lord, that
Let us be clear on facts.
Yes.
Admittedly, the judicial proceeding has nothing to do with his service.
my lord, why, my lord, that criminal proceeding was started due to one loan was taken by that applicant?
We are asking you, it is at your instance. No,
And-
it is not by the employer.
My lord,
So it is not in relation to service.
My lord,
Now that is an admitted position.
my lord, kindly consider one thing. My lord, that person was arrested. And
He
my
may
lord,
be, he may be convicted
custody,
also.
my lord, the police authority intimated to the railway officer.
So therefore, what is the consequence?
Thereafter, my lord, he was suspended from his
So
service.
what is the consequence? It becomes a matter relating to service. If it was intimated, it becomes a matter relating to service. Why you are saying this? What is the consequence of such a submission? How does it help your case? He went to jail, he was arrested. It happens whenever anybody is accused, they go to jail.
My learned friend raised
It's
the
a big
question
deal.
whether I am entitled or not. They have already
Point
paid.
is that you have already paid them.
Yes,
So
that-
there is no question of entitlement now.
My lord, if there was any delay, my lord,
Yes.
that delay was occurred due to the pendency of the criminal
Still
case,
pending.
which was, my lord, filed by the, my lord, the Oriental Bank of Commerce.
So that the criminal case is over.
No, my lord,
Still
still
pending.
pending.
What a wonderful submission you are making.
That is still pending. And my lord, that before the learned
There's
tribunal,
nothing. Sorry.
My lord,
before the learned
during the
tribunal,
pendency of this,
before the learned tribunal, according to this, my lord, recent judgment, my lord, there was that fact was also not considered at all whether, my lord, there was any interpretation of any rule
You have paid it. Where's the question?
or, my lord,
You have paid it yourself.
2000 from
What
2018
prompted
they
you to
never
pay?
raised
What
this
prompted
mistake.
you to pay during pendency of the OA? What prompted you to pay? Just tell us that reason. Why did you pay? In 2022, why did you pay? What circumstance changed? Kind of case you are arguing? How can you cannot improve this situation. Since 16 to 22, you kept it because you didn't like the person's face. What was the reason? And what changed in 2022 that you gave it to him in November? That yes, now we think you should have it. Then what can you do? You have to pay interest. Yes, take down.
My lord, my lord,
Heard
may I
learned
submit
counsel
one
for the
as per the Provident Fund, Railway Provident Fund ratio, the ratio of the interest, my lord, the ratio of the interest. My lord, as modified, your lordship. No, my lord. My lord, kindly see. There is a, my lord, misunderstanding, my lord. My lord, kindly see the,
What is it? Tell us.
my lord, the ratio of which the interest.
The gratuity carries interest on that.
The Railway Provident Fund account applicable to the Railway Provident Fund account as per the railway.
No, the due, whatever due interest, you will get it.
The ratio.
The tribunal has not granted any penal interest.
No, not as per the ratio of the. Provident
Whatever
Fund
it is,
ratio.
due interest, you will get the due interest. Yes. Due interest, due interest.
Number 10.
Item 10, my lord. I'm for the petitioner, my lord. I'm praying for 2 weeks adjournment.
My lord, in item number 10, my lord, I am appearing on behalf of the applicant respondent. My lord, in this matter, my lord, I filed one modification application before the learned tribunal. Only lordship, some typographical error in the order, my lord. If your lordship kindly postpone for some after.
As prayed by petitioner 2 weeks.
If your lordship kindly grant a urgent server copy, my lord, because but from 1st July, my lord, the bench will be functioning in tribunal, my lord.
You will get it, don't worry.
Get it, lordship.
Number 11.
I am appearing on behalf of the applicant. Have served the petition, but this is challenging and stay order granted in respect of transfer. There were various transfers. This is from Kalaikonda Airbase to Panagarh Airbase.
Airbase.
Airbase. Both are airbase. There are some of them are painters. This is also a fact in issue. Some of them are a paint. One of them is painter. Rest are high skilled electrician. The first one, the PT in item number 11, he is a painter. He is high skilled painter. They have been transferred.
They are non-combat.
Non-combatant. This is a promotion cum posting order.
So you filed your reply.
Well,
Did you file your reply?
I do not know if any reply has not been filed.
By now it could have been resolved.
No.
Yes, 23/6 is the date. Why didn't you file a reply?
We are challenging the stay order passed.
So therefore you will not file a reply. Even if it is vacated. Even if it is vacated, you have to file a reply. 23/6 is that date is also gone, and now you want us to vacate the order.
23/6. I do not know if inspection.
We know it is there in the order.
No. Huh? We have sought for time to file.
Very well. If you don't want to, then what can be done?
No. We will, my lord.
Whether you are having any urgency
Only on the issue of stay, my lord. Nothing.
We are on that only.
My
If
lord.
there is any semblance of urgency, it would have been apparent from your conduct. You are more interested in litigating.
My lord, they have been released, my lord. They have been released from their, they are not joining, my lord, in their transfer.
Therefore, the matter was fixed on 23/6. You could have filed a reply by now. It could have been thrashed out.
It has not been filed. Are you sure it has not?
If this is your conduct, then what do you expect? You are not showing any urgency. These painters and all these people, for them, you are pursuing it like this.
No, no. My lord, kindly see the reason assigned.
We have seen you are relying on judgment for combat people. They say it will not apply to a non-combat people.
Judgment, my lord.
Plus,
fact
they have raised an issue regarding children's education. Your speaking order does not consider that.
My lord, kindly see one judgment of the Honorable Supreme Court.
Sir, it is,
It has been
it does,
laid down that you join there and then make your application. In this case, they have made an application, we have considered it and then passed.
therefore, once you have considered it, are you not required to consider everything? That may not be binding, the policy may not be binding. There is no mandate that as per the policy, if there is a children education issue, you have to accede to the request, but at least you will consider. So these are the prima facie findings of the tribunal. Plus, you are here against the interim order. You are here against the interim order and already a one date has lapsed there. And as if you have a lot of urgency, you did not file a reply. So it will remain pending here more because now we will issue notice to them. Choice is yours.
But my lord, this problem is, my lord, the same case.
Sir, our problem is, can we proceed without them? Once they have an interim order in their favor. Should we?
Kindly then issue notice, my lord.
So there is no problem with continuance of the interim order.
No, we will seek, my lord, your lordship will not pass. But my lord, we want to challenge it on merit whether an interim order can be passed in this circumstance. So what was in the circumstances and the facts which were there before the learned tribunal. Your lordship kindly see what is.
And did you have the option of filing a petition for vacating the stay?
My lord, there are 3 other matters. Vacating has been filed. Those matters have not been taken now. We have been instructed to file appeal against those also. I have refused that since you have already
Maybe if that comes, we don't know. But in
No,
this
we have-
case,
this is the problem we are facing. Well, same cases possibly same transfer order. 8 or 9 into one bench has refused interim order. They have came up during the vacation before the court, my lord. Interim order has been refused. In 3 already interim order granted. We have filed vacating, and those are not being heard. And these are the 2 matters we have been instructed to challenge, my lord. 2 matters we have been instructed to challenge.
as let the notice be issued. Let notice be issued by speed.
Second matter.
Next.
Same.
Designation is same. One is painter, one is
Those. Yes, same order.
affidavit of service may be recorded, has been submitted. That may be recorded in the order.
What is it?
Affidavit of service.
Acha, affidavit of service taken on.
In this matter, my lord, Mr. Tanmoy Mukherjee appearing for the petitioner. My lord, he is suffering from a fever. My lord, kindly make it not today. Only not.
Not today.
Item 14. Not here. Well, may I find my written notes, man?
My time.
Copy is given.
Yes.
You are also filing before argument.
Below the judgment.
That we consciously did not deal with the argument that was made on behalf of the state legislature advocate on the point. The maintainability, since the order has been passed due to the pendency of the proceeding, since this honorable bench will not observe that this can be done prima facie. So I consciously will not avoid to deal with this because I came across Millard this point of law today when I in the morning Millard when I was served with this. Millard, they rely on the Chandra Kumar, saying that I should have gone there. So Millard, since this point, Millard, on the threshold, Millard, the bench has answered. Now, Millard,
No, we have not answered. All the observations we are making right now, all
but
are.
I have not, Millard, given the answer, Millard, in this because now, Millard, this has come. So let my learned senior friend argue. Let me get because unless I get to know his mind, Millard, I cannot respond. But the way Millard he has dealt with, I have gone through his argument. Millard, all the premise, Millard,
What order has been passed after the tribunal's order?
the tribunal asked them to consider the representation. Now, your lordships wanted me to place before your lordships what were the actual prayers made before the tribunal. Now, when after going through the prayers, Millard, your lordship found that other prayers are also there. With tribunal, possibly, Millard, as per my understanding, humble understanding, tribunal has a duty to decide all the disputes. There are other prayers. Now, Millard, on that score, Millard, possibly, subject to correction, Millard, the prima facie observation, Millard taking the last resonance of your lordship's observation that it was a prima facie. But this was the occasion for which Millard, your lordship responded to this submission. Now, Mr.
Where is he?
So,
Matter below.
so I could not, Millard.
Let him be here.
So, Millard, my respectful submission that what was my point? Because the bench, Millard, prima facie, I would say that the cutoff marks, my specific cases was fixed on the last date, that is after selection is over. This was fixed, and Millard, I was excluded. I fall under Millard, the horizontal reservation. My submission had two compartments. First, the Shourab Jadav's case, paragraph 23.11 and 43, the manner in which the Supreme Court has said that it has to be done, and my quota has been abolished, and Millard, only one candidate, selected candidate, that is my client. Millard, he was excluded from the zone of consideration, and the representative that my entitlement under this category, that my participation is representative in the nature of public service. Such right, Millard, has been curtailed. Now, question is that why it was curtailed. It was curtailed according to the Mr. Mukherjee, my learned senior friend's client, understanding that the cutoff marks has been fixed on the day when the provisional list was published on 9/2/2024. After selection is over, I can do it. My lord's query, subject to correction if memory does not betray me, that what was my stand, whether cutoff marks cannot be fixed. My submission to that, my lord, subject to correction, that it has to be incorporated in the rule. My lord's observation, prima facie, that rule 11 clearly says that after the interview and written, this can be fixed, and this was rightly fixed, prima facie, after the selection is over. Supreme Court, my lord, possibly relentlessly, my lord, has taken a consistent stand, which, according to my humble understanding, my lord, it stands in my favor, subject to what my lord will say. My lord.
So, what is a cutoff mark?
I got 68 point something.
What is a cutoff mark?
Cutoff marks, the Supreme Court kindly says paragraph 15.
Paragraph
15 of my written notes. Page 5.
Yes.
May I be allowed to?
No, we are not on the manner. We are on what is a cutoff mark.
Cutoff marks, Millard, has to be made that these are the benchmark, has to be made, has to be incorporated in the rule, and has to be made, Millard,
Cutoff mark has to be incorporated in the rule.
power to do in the advertisement. It was all in the advertisement. In this case, Millard, it did not find place in either of them.
So
First of all-
therefore, if there is no specific provision saying that employer is to fix a cutoff mark in so many words, then
You cannot do it. The authority
the-
cannot do it.
then the
After
list has
selection-
to be
No,
operated all the
The
way.
authority cannot do it after the selection is over. My respectful submission, Millard, at the cost of tiring repetition. I do not take any-
Selection is over.
Yes, selection is over means that I crossed all the 4 stages as per clause 8 of the rule, Millard, which I have shown to your lordship. Millard.
Yes, that
Yes,
we have shown.
yes.
The last stage was interview.
Yes, last stage was the interview. I qualified in all stages. You did not say, you means Millard state that I was found to be unsuitable. That is the appropriate term. So you allowed me to participate in, meaning thereby it is inherent that I qualified at all stages. And not only that, the factum of unsuitability must be in the finding. So in absence of the finding of unsuitability, Millard, the cutoff marks after the selection is over, in the all stages, 4 stages, you cannot, that the state cannot say it.
So if
Judgment is, Millard.
So if there is a X number of vacancy and X plus 100 qualify, then what is to be done?
Millard, then Millard, what is to be done means, Millard, that is the answer in the judgment, how is to be done. And that is as against
So
the fact.
therefore, the moment there is a qualification of more candidates than the vacancies existing,
Suppose Millard, cutoff marks is.
no, forget about cutoff marks. We are not on cutoff marks. We are saying X number of vacancies, X plus 100 qualified. Then what is to be done? X plus 100 to be allowed, appointment.
No, that is the answer, Millard. Number of vacancies, it proportionate with the number of vacancies.
So therefore, the moment the qualified people have to be segregated with reference to the number of vacancies, there has to be somewhere where it has to be.
That is
So
what-
that is the cutoff marks.
Yes, the filling of
So-
the last vacancy, last number of vacancies. Suppose 90.
Therefore, rule need not say this. The last person will be
This has
the
not
cutoff.
been done.
Yes.
This has not been done.
In this case, this has not been done.
No, 94 vacancies, suppose Millard, 94 vacancies, and I was the only candidate who Millard happened to cross all the stages. So there has to be a specific finding regard to the unsuitability. That is the finding of the Supreme Court. Have you found him unsuitable? Answer is no.
No, even after being suitable. If the performance is not,
Yes, that is
if the
question.
performance is not
Or-
above the last
Yes,
candidate,
When your lordship says, it is a conscious choice, Millard. When your lordship says that I'm not, that performance, Millard, it is inextricably intervened with, Millard, the word, Millard, unsuitability. My performance is not up to the mark. The desirability, Millard,
no, not up to the mark means your performance is not at par with the last person.
must be with reference to the context. No, that is the answer. Because in that category, there was no other selection. Other selection.
Maybe. So therefore, now the issue is there are 3 categories. One is a UR. Second is a, no, you are not UR. You are.
Unreserved home guard.
So therefore, you are with horizontal reservation. That is the next category. It will be below UR. It cannot be at par with UR.
That I belong to UR. HG.
You belong to
94
UR, but you are having a benefit or claiming a benefit of horizontal reservation.
Right.
So therefore, the last selected candidate in UR, whatever marks he has, for you the mark should be less than that. Because you are seeking a horizontal reservation.
Now, my lord, if your lordships are with me with regard to the specific number of vacancies declared under the horizontal category, the number is fixed and certain.
No, maybe there may be. We are not on whether there is vacancy or not.
The 94 has to be added in the context of only one candidate, that is my client, who has crossed.
That you have said, we have understood.
Now, my lord, then, my lord, the question is then how it is to be determined. Let us, my lord, or permit me, my lord.
We will see that. We'll see that. What I am saying is that after the last UR category person has been selected, the marks has to be scaled down for the horizontal reservation. It cannot be at par with the last UR category.
What my lord Saurabh Jadhav says.
So therefore, Then after that comes the BC. For BC, a third category has to be fixed. Now the UR horizontal reservation who is claiming in UR category, their marks will have to be somewhere between the UR and BC.
That answer subject to correction. No is may not kindly do not take me that this word no, which comes from my mouth as an arrogance. It is my humble understanding since the bench has Millard ignited, asked to Millard to make the law.
Yes, please.
Kindly Millard, because Millard, I must be very conscious, Millard, I am addressing the highest court of the state. Millard, the first query, Millard, that is the first query to work out.
This has to come somewhere in between BC and the UR.
Millard, kindly Millard, allow me. Millard, if your lordship permits me, Millard.
So just give us a few facts, then we'll hear you. So for BC, what is the cutoff marks in your selection category, in your selection process?
Millard, my respectful submission, Millard, I repeat, that Millard, the cutoff marks cannot be fixed, Millard, unless Millard, I was notified.
Unless?
I'm notified. Because in this case, I was never notified. It is neither in the rule, nor in the advertisement, nor at any stage of selection process. Stages. First preliminary, then physical efficiency, then written, then interview. If your lordships are convinced with this proposition, then it comes to Millard this question. Otherwise, if I say that you cannot enter.
No, we see ultimately we have to see what will be the result of this entire argument. What will be the result? What will be your gain? How the situation will change?
Kindly sees, Millard.
If the situation does not change, if the BC category cutoff is above what you have got, can you claim to be a horizontal?
I can claim because the decision-making process, because it is a different. Millard, if my argument, the first part of argument, that you cannot decide a cutoff marks, so-called cutoff marks, without there being an SB's finding of unsuitability at any stage, then such cutoff marks on the date of final provisional publication of the provisional list, after the entire selection, that is 4 stage is over, you cannot do it. If that is the Millard, the question of jurisdiction, it Millard goes to the root of the matter. That is why Millard permit me to address your lordship, Millard, in my own humble way.
So is there anywhere on record the cutoff marks for BC category candidate?
BC?
Yes.
That's it. Millard, my respectful submission that if the power is not with them, then Millard, the cutoff marks that was fixed on 9-2 in respect of all the categories, Millard, all are irrelevant and redundant.
Maybe, but what is the cutoff marks?
Page 159 of the petition.
Yes.
I see on the day.
So where is the BC category cutoff? OBC, yes. And what is the marks obtained by you?
60, 5.83.
65.83.
And they said 68.92.
Yes, that we are looking at 68.9. All right, you may proceed now.
Yes. But I'm extremely grateful.
You are referring to the judgment.
Yes. Paragraph 15 of my written notes of argument.
No, where's the judgment? Let's see the judgment.
Judgment.
It is, we have it.
No, 2024 6 SCC was not. I have not annexed it.
24/6 SCC.
2024 6 SCC.
Oh, that you have not given the.
Yes.
Yes.
22 to 24. May I start reading?
Just a minute.
I'm sorry.
Twenty-two.
22 24. May I read? We find from Rule 18 of the 2001 rules, the task of setting cut-off marks has been vested in the High Court. But this has to be done before the start of the examination. Thus, we are also dealing with a situation in which the High Court administration is seeking to deviate from the rules guiding the selection process itself. We have considered the High Court's reasoning for such deviation, but such departure from statutory rules is impermissible. We accept the High Court administrator argument that a candidate being on the select list acquired no vested legal rights for being appointed to the post in question. But if precluding a candidate from appointment is in violation of the recruitment rules without there being a finding on such candidates' unsuitability, such an action would fail the Article 14 test and shall be held to be arbitrary. The reason behind the full court resolution is that better candidates ought to be found that is different from a candidate excluded from the appointment process being found to be unsuitable. Stipulations contained in rules such and such, rules for making the select list were breached by the High Court administration in adopting impugned resolution. The ratio of the decision in Ram Saran Moirua would not apply in the facts of this case, and we have already discussed why we hold so. Mr. Gupta's stand is that applying a higher aggregate mark is not barred under the rules or regulation. We are, however, unable to accept this submission. The very expression aggregate means combination of two or more processes, and in the event the procedure for arriving at the aggregate has been laid down in the applicable rules, a separate criteria cannot be carved out to enable change in the manner of making the aggregate marks. And this one. And Millard, yes, then I will, Millard, go to Manjusri thereafter. Then Millard, kindly comes to Millard, my next para, that is Millard, 87 4 SCC, page Millard 646.
So in this case, there was a rule which the apex court found to have been violated.
Yes. And
apart from that, paragraph 2,
the first sentence, Millard,
paragraph 2 of this judgment and paragraph 10 gives the factual premise in which the judgment has been passed. Yes, which other judge?
87.4 SCC. But the paragraph 22, Millard,
Correct.
they said it has to be done before.
Yes, that rule required, sir.
In absence of the rule,
That rule required,
The
and the
last
full court introduced a 50% aggregate which was never there.
question is here, I will rely on a judgment because I submitted that if the rule is silent, then Millard 87.4.
This is not the judgment on that point. That if it is silent, then also it has to be declared before the selection process.
87.4 SCC, Millard, I mean, hand code?
Yes, we have it.
Yes.
Durga
Kindly
Charan
comes, Millard,
Mishra.
Yes. 7, 8, 11, 15. 87.4 SCC 6.4 6. Written notes lekha ache. You kindly consult your written notes. The rule-making authorities have provided a scheme for selection of candidates for appointment to judicial post. Rule 16 prescribed the minimum qualifying marks to be secured by the candidates in the written examination. It is 30% of the total marks in all the papers. The candidates who have secured more than that minimum would alone be called for Viva Voce. The rules do not prescribe any such minimum marks to be secured at the Viva Voce test. After the Viva Voce test, the commission shall add the marks of the Viva Voce test to the marks written. There then Rule 18 states, the names of the candidates will then be arranged by the commission in order of merit. This is the mandate of Rule 18. The commission shall add the two marks together, no matter what those marks at the Viva Voce test. On the basis of the aggregate marks in both the tests, the names of the candidates will have to be arranged in order of merit. The list shall be prepared, shall be forwarded to the government. The commission has no power to exclude the name of any candidate from the select list merely because he has secured lex marks at the Viva Voce test. Then Millard 11. In the light of this decision, the conclusion is inevitable that the commission in the instant case has also no power to prescribe the minimum standard at Viva Voce test for determining the suitability of candidates for appointment as munsifs. Then Millard 15. The rules have been framed under the proviso to Article 309, read with Article 234 of the Constitution. Article 234 requires the appointment of persons other than the district judge to judicial service
Yes, we have seen introduction of a minimum qualifying where there was none under the rule. What else?
Now, Millard, 2011 SCC online, Calcutta 1581.
20?
Millard, only the last sentence, 15, the last paragraph,
of
it
this.
cannot prescribe additional 87. It cannot prescribe, sorry.
Yes.
Cannot prescribe additional requirements
Correct.
for selection, either at eligibility. The decision of the commission to prescribe minimum marks to be secured would therefore be illegal.
That's what we are saying. They have made the interview qualifying, whereas this was not the rule. The rule said only the marks has to be added. Therefore, that is clear. Don't worry.
Then Millard, 2011 SCC online, Calcutta 1581.
2011.
And just now. '29. 2011 SCC online. So my written notes, I have given everything in my written notes. Reference is there. Paragraph Millard, 2011, 29 to 32, 34 to 37. The respondents to the writ petitions have categorically stated in their affidavit in opposition that the selection was to be held on the basis of physical efficiency test, written test, Viva Voce, and 200 marks were earmarked for written test alone, and 100 marks were earmarked for the Viva Voce, for which there was a mention in the concern notification. It was also asserted that physical efficiency test was only a qualifying test carrying no marks. This seems to be more consistent with the conditions laid down in the physical efficiency test would be put through written test in general knowledge, English, and essay. The concerned employment notification merely mentioned the marks allocated to written states. The marks for interview were not mentioned. This does not mean the entire written examination was held to be held on the basis of 200 marks allocated for the written examination. When interview was also a mode of recruitment, it is not fair to presume that interview would not carry any marks at all.
The respondents to the writ petitions had supplemented it by stating that no additional marks were added by the selection board, 100 marks for the vivacious test and 40% as its minimum qualifying were earmarked by the circular issued by the Director General of RPA by its notification dated such and such. Then, my lord, kindly comes to 32. Mr. Gupta's contention that the employers cannot deviate from the conditions laid down in the concerned employment notification is far too well accepted. It also very well settled that an employer cannot deviate from the qualification published and recruitment in the deviation of the published qualification would violate article such and such. It appears that the case in hand involves the case of deviation of mode of selection from the published one. The notification was silent about any qualifying marks for the interview, but the appellant stuck to the instruction that the qualifying marks for the interview would be 40% and irrespective of marks obtained by a candidate in the written examination, if he had failed to obtain the minimum qualification marks in the viability test, he was declared to have failed in the examination. The other contention of Mr. Gupta that the allocation of such high marks for the interview may lead to arbitrariness is likely to give a handle to the employer to adopt a pick and choose policy. Then kindly comes to paragraph 34 to 37. At this stage, we may again refer to the judgment of Himani Malhotra versus High Court of Delhi, Supra, relying
This
on
case is the same as Durga Charan Mishra, introduction of qualifying marks, where the rule said there was to be none.
Yes, yes. And Millard 36 said the appellants may very well argue that the cutoff marks for interview was fixed long before the employment. As such, there was no question of prescribing quality. The solicitation was over. This argument, though chronologically just is otherwise not justifiable, a prescription of qualifying was not made.
This is contrary to rule. Where is the question of stage?
It was not made known.
Huh?
Decision not communicated, made known to. That is the language.
It was not in consonance with the rule to begin with. The rule said Viva Voce was to be included within 200. What they said is Viva Voce will fix a qualifying 40%.
In this case, there is no fixation. I was not known. I was never aware of this, that this should be done.
There is no provision here in the rule in this regard.
The question is how the silence.
We have yet to see where there is a requirement of fixing a cutoff in the rule or from these judgments we have not seen.
The rule to fixation is a
because your specific case is unless there is enabling provision, they could not fix a cutoff. We are saying a cutoff mark emerges from the last candidate's performance. There's no question of fixing a cutoff.
I said if the rule is silent,
then no cutoff can be fixed.
No, either then my lord, at every stage they must inform me. I said I must be made known to that.
The result is the information.
I said the last selection, my lord.
But we are looking for the law on this. You have said this. We are finding it a bit
difficult to.
We are being very clear. Therefore, we are asking you. Therefore we are asking you because normally the concept is the last selected candidate's marks emerges as the cutoff. Or if there are very many categories to be accommodated, then like Saurav Yadav's case you are reading, there is another judgment which I have seen, I can't recollect, I don't have memory like you, that
kindly, I am pleasantly embarrassed, my lord.
No, you should not be. That these marks have to be, cutoff marks have to be set by the employer, keeping in view the efficiency required without compromising on the next level. So the unreserved horizontal beneficiary will come in between unreserved and BC. His marks cannot be below the BC and therefore it has to be fixed. There is a compulsion to fix it to work out the reservation.
I bow down. Millard 68.92, the cutoff marks that has been fixed when my case is very specific and certain that under this category no one Millard has called it, then under what circumstances?
You are the sole candidate.
Then Millard, such fixation is Millard absolutely illegal.
So if the sole,
I do not know whether your lordship will subscribe this view. Millard, this is my own innovation at the risk of my reputation. Millard, every decision making, Millard, kindly come after 15 minutes. I will take a coffee.
Yes. For this, you were looking at Calcutta, we have seen. These three we have seen. This he has already placed. This three has been placed today. This one was placed on the last day. Saurav Yadav also is already placed.
Your lordship's query with regard to the non-incorporation, that is my submission, that if the rule is silent, then what is the ramification of such thing when it emanates from mere salutary power or from a state authority? Milord, I am extremely sorry.
Only on cutoff marks.
No,
Only with regard to cutoff
Milord,
marks.
anything, Milord, that anything, because it ultimately demolishes my right not to be indefeasible right to be appointed, but my right to be considered.
Considered. Correct.
Consideration, Milord, that is consideration, Milord. Milord, if I say
no, but the other factors in a recruitment process and cutoff marks are totally two different things. Cutoff mark will emerge in every recruitment process. It has to.
Absolutely.
Cutoff mark, there can be no recruitment process without a cutoff mark. There can be no admission process without a cutoff mark.
But how it is to be?
And that will emerge in the process of recruitment based on the marks. Qualifying marks can be prescribed. Cutoff marks, how it can be prescribed?
Cutoff marks, that is why.
It can only be done after all the applicants have participated, they have been assessed.
Ultimately, the ramification, Milord, it has been blurred, these two concepts, because the cutoff marks becomes a qualifying marks.
No, it does not.
In this case, this has happened.
A cutoff marks results in your non-selection does not mean it becomes a qualifying mark. Every qualified candidate need not be selected.
Right. But question is, Milord, what
so
is
therefore there is no
Milord,
parity
Milord,
between the
Milord, it amounts to conversion.
You say it has become qualifying because I was the only person and I was not selected. That is your case. There were 94 seats. I was the only candidate in the category. Therefore, this cutoff mark has become a qualifying mark. I am obliterated from the recruitment process.
So, Milord, I have shown, Milord, 2011 SCC on line 1581 and 34 to 37. Next, Milord, 2016 SCC on line 12174. No. Calcutta bolchi.
Why do you want to multiply on the same issue?
No, Milord, not. I am saying,
unless there is another issue, why should these three judgments are enough on that point?
Milord, I'm only, Milord, these are last on the point of cutoff, possibly.
No, these are none of them are on cutoff. All these are on a change in
Permit me, Milord. This is, Milord, 2016 12147. Kindly cease. My Lord. There are two copies.
Yes, there are two copies.
Yes.
None of these are on cutoff marks. All these are relating to
from the provisions of the rules 19 Milord paragraph. It is explicit that the PSC had no jurisdiction to specify any cutoff marks for personality test. Under the said rules, the Commission was required to prepare a list of candidates approved by it for appointment to the service, and that the list of selected candidates should be arranged in order of merit on the basis of aggregate marks finally awarded to each candidate in written as well as in viability test. The contents of the advertisement and syllabus and scheme do not reveal that the candidates were notified about any specification of cutoff marks prior to the examination. From the contents of the resolution
dated such and such, it is explicit that on the said date PSC decided that accepting West Bengal Civil Service Executive, etc., examination and West Bengal Judicial Service, in all cases of recruitments and examination, qualifying cutoff marks will be fixed at all stages for all categories as in selection cases. Thus, PSC included an additional criterion of selection after commencement of the selection process. PSC could not have its own whim at any point of time without notice to the candidates fixed cutoff of the personality test. As such, we do not find any infirmity in the observation of the learned tribunal to the effect that PSC had changed the rule of the game in the midway and also deviated from the provision of the recruitment rules.
Therefore, we are saying all these judgments are on the same.
But
Why-
2020 is otherwise.
All of them are whether
What is the rationale?
whether the rule prescription can be altered. All of
No.
these are on that issue.
It said it cannot. Milord, kindly see the
Because
rider
there
in
is
the
a rule prescribing no such marks is to be.
Milord, I will have, Milord, it says it has to be read pertaining to the vacancies. The aggregate is the rider in the said rules to the effect that PSC shall have the discretion to fix the qualifying marks in the aggregate has to be read pertaining to the vacancies. The aggregate is the last stage of selection and is restricted to the number of vacancies, unlike the first stage of selection being the written test, where the cutoff is relatable to the ratio of the vacancies with the number of candidates who apply pursuant to the advertisement. So that is what your lordships are trying to find out, possibly. The rationale behind the fixation, the scheme underlying the same rules, does not lead to any conclusion to the effect that obtaining cutoff marks in the Bhayabusi and in the aggregate was a sine qua non before the PSC could
Correct.
proceed.
So in all these cases, that's why we are saying you are multiplying judgments on the
I am
same
saying-
issue.
I am saying
There is
that-
a selection process of 3 stages. Marks are to be added and on the basis of aggregate assessment is to be done. Instead of doing that, one of the parameters, they are fixing a qualifying or cutoff mark,
When the
which
selection
cannot
is-
be done. This is contrary to the rule in all these 4 cases.
Yes, now Milord, if the rule is silent, then what is the ramification?
You are saying that cutoff marks, you are not referring to any rule.
I
You
am-
are saying unless cutoff marks is fixed
I am
beforehand, it cannot be.
No, I said the rule is silent with regard to the fixation.
So
It cannot
therefore,
be done.
therefore there
you
can
cannot-
be no cutoff marks.
No, I said it has to be in the rule or in the advertisement.
Or it cannot be done.
Cannot be done.
These
And Milord,
judgments
this is-
don't support
my,
this view.
my submission, Milord, finds strength. It is my humble understanding. This I will give a photostat copy, Milord. Sorry, Milord, this I could not find it. 2013, volume 2, CHN, division bench of your lordship's court, paragraph 12. Why the silence matters, Milord? 171, 2013, volume 2, 171, Calcutta High Court notes, paragraph 12. I will read only 10 paragraphs. 10 lines, 10 lines. As already discussed, as far as the permission sanction of a building plan, it is not within the jurisdiction action of the Pradhan. As such, there was no need to meet the Pradhan at all. It is the Gram Panchayat who has the power to refuse any application seeking sanction of the building plan. It is the Gram Panchayat only by taking a resolution to that effect, identifying the defects thereto any, if any, will proceed under the rule of sub 27, sub rule 3 of the said rules. It is a settled legal position of law that statutory body must act within the framework of the statute and cannot travel beyond the statute. One individual can do all things save and except those which are prohibited under the law, whereas statutory body only can do anything as are prescribed within the jurisdictional parameters or control of the concerned statute. Reliance was placed, Milord, from Calcutta CWN to Supreme Court 74 SCC 2008 also. So I said such silence cannot be construed, Milord, to the extent that it is embedded in the rule, that it can be done. My first limb of submission, cutoff marks.
Who is saying that it is embedded in the, whose case it is? You are offended by a cutoff mark. You are assailing that cutoff mark. You are saying it has resulted in your exclusion from the recruitment process. So why that cutoff mark is vitiated? That you have to say. Nobody is saying that under this rule and that rule we have done it. The concept of cutoff mark emerging in the course of assessment is well known. It has to emerge. There can be no recruitment or admission without a cutoff. Cutoff and qualifying are two different things. Qualifying will exclude the candidate. Once those who have crossed the qualifying, they will be part of the assessment. And from amongst them, as per the vacancy, a cutoff has to be fixed.
I'm extremely. Milord, my answer with humility, Milord, that there are three things are very important, Milord, and relatable to each other.
Number one, the cut-off marks cannot be treated as a qualifying marks. I bow down.
Cannot be.
Cannot be. Number of vacancies 94. Out of 94 under the same category.
Only one candidate. You are the sole candidate.
Then, what is the rational or mathematical basis, my lord, with regard to the fixation of cut-off marks of 68.92?
So that is an issue. That is an issue.
It is
That may
actually-
be an issue.
That,
That
my lord,
may
then,
be.
my lord, then in law, everything is reference to context. Then such cut-off marks has to be a reference to a context amongst the same group, not from the other group.
No. Cut-off marks cannot be from the same group.
If that
It
is,
has to be in between the UR and BC.
my lord,
It
UR
cannot be
and-
dehouse
my lord,
these two
UR and
categories.
BC, then, my lord, UR and BC, your lordship says that suppose that BC, some persons are more meritorious than my client, then they have to be accommodated first.
No.
94
They will go in UR. They will not go in your category.
UR.
If they are even better than you, then they can go in UR.
Question is, what is the case made out there? What is the case?
What is your case? That's why we are asking you.
I am saying.
Are you saying that the marks?
I have three arguments. Cut-off marks cannot be made in the fashion that has been done. It has to be at the threshold. Number one. Number two, the judgment which I have initially referred, that particular paragraph 22, it says in the second line of the first paragraph 22, that it has to be done before. Now, High Court said, second, if the cut-off marks has been fixed.
Those judgments are not on cut-off marks. They are on qualifying marks being introduced.
And Miller, the last judgment.
Therefore, cut-off and qualifying cannot be. The last judgment also says cut-off. But the facts reveal that it is more or less the same.
And Miller, Saurabh Jadhav.
So therefore, the concept of cut-off marks emerging in a recruitment process with reference to the last candidate is the issue here. Not a barrier insofar as assessment is concerned. In those cases, a barrier has been introduced in the recruitment itself, which was dehouse the rules. In fact, contrary to the rules.
If your lordships are of the prima facie opinion that my understanding of the judgment of Himani Malhotra, K. Manjushree, that is my respectful submission.
Which one?
Last judgment.
The one as SCC Cal.
22, 2 SCC.
Yes.
2 SCC. One, I have given my humble understanding, my lord, subject to what my lord.
25-2.
5.
Yes, we have it. Yes.
Yes, 25-2.
Tej Prakash Pathak.
Yes. Tej Prakash Pathak.
13, 14, 15, 16, 17, and 23, 24, and 33.
Yes. 29 paragraph.
That you have, yes, you have already.
No.
No, not 29. 23,
No, I have not
24.
said. 29 I missed, my lord.
Oh.
K. Manjushree, the recruitment exercise was for selection and appointments to the post of district session judge. The extent rules prescribed the eligibility qualification but were silent on the procedure for selection. The manner and method of selection was therefore decided by the High Court for every selection as and when the vacancies were notified for selection. The vacancies were notified by the state government. As per the advertisement for selection on written test examination, followed by an interview, the administrative committee of the High Court resolved to conduct written for such and such marks and interview for. It was also resolved that minimum qualifying marks for open category such and such shall be prescribed as earlier. Next, then 49. 49 to 50. 49, 53. 49 and 53. The ultimate object of process of any selection for entry into a public service is to secure the best and most suitable person for the job, avoiding patronage or favoritism. Selection based on merit, tested impartiality and objectively is the essential foundation of any useful and efficient public service. So open the competitive examination has come to be accepted almost universally as the gateway to public services. It is now well settled that while a written examination assesses the candidate's knowledge and intellectual ability, an interview test is valuable to assess candidates' overall intellectual and personal qualities. While written examination has certain distinct advantages over the interview test, there are yet no written tests which can evaluate candidates' initiative, alertness, resourcefulness, dependableness, cooperativeness, capacities for clear and logical presentation, effectiveness in the discussion, effectiveness in meeting and dealing with others, adaptability, judgment, ability to decision, ability to lead such and such. Thus, the written examination assesses the man's intellect and interview test man himself, the twain shall meet for a proper.
What is clear from the above is the object of any process of selection for entry into public service to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method procedure to select a candidate most suitable for the post, albeit subject to the overchanging principles enshrined in 14 and 16 of the Constitution, also the rules statute governing service reservation. Thus, in our view, the appointing authority, recruiting authority, competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post. While doing so, it may also be set benchmarks for different stages of the recruitment process. Different stages, my lord, I am putting emphasis, including written examination interview. However, if any benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extent rules of the advertisement inviting applications empower the competent authority to set benchmark at different stages of recruitment process, then such benchmark may be set at any time before that stage is reached, so that neither the candidate nor the evaluated examiner interviewer is taken by surprise. The decision is K. Manjushree does not prescribe setting of benchmarks for various stages of recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This in view of the consonance of the rule against arbitrariness enshrined in Article 14 and meets the legitimate expectation of the candidates, as also the recruitment for transparency in recruitment to public services, and thereby obviates malpractices in preparation of the list. As already noticed in Section A, a recruitment process inter alia comprises of various steps like such and such. We have read, Miller. Subject to the rule, I am reading, Miller. Application scrutiny for 54. 53. Oh, sorry, 53. Recruitment to the public thereby obviates malpractices. So this is Miller, then and Saurabh last. Miller
23.11 and 43 you have already placed.
Yes. So Miller, whether the journey, Miller, that has been undertaken, Miller, and the last, Miller, that question is, Miller, the court must be informed the reasoning, because no records have been produced before your lordships that how the marks have been calculated as regards the different categories. And Saurabh Jadav's, Miller, the submission I have made in paragraph page 8 in written notes, may I be permitted, Miller, your lordships have given enough indulgence, Miller. Miller, I bow down to your lordships, Miller, only. The respondent authorities, page 8, the respondent authorities have not followed the method of preparation of merit list in terms of Saurabh Jadav, Miller. The number of vacancies for unreserved category, including for horizontal reservation, was 546. You are 283, exempted 87. You are home guard 94, that is my category. You are civic volunteer 59, and you are sports category, Miller, 23. Therefore, the authorities were required to prepare a list of 283 candidates in order of merit by combining the marks of written and interview without applying any cut-off marks. Thereafter, the authorities were required to check, for example, the number of home guards who are within such 283 candidates. Had it been the case that there are 94 home guards within 2883, then the horizontal reservation with regard to home guard would have been complied with. However, there was no candidate within such limit. Then the authorities ought to have gone down the list of candidates in order of merit and looked for 94 home guards who have passed the interview. In the instant case, there is only one candidate, which is the petitioner. The name of the petitioner was required to be placed in the list of provisionally candidates as UR home guard, and the rest 93 vacancy could be de-reserved to be filled up by UR candidates from 284 candidates. However, the respondent authorities filled up all vacancies of UR home guard by UR candidates from the 284 candidates, thereby defeating the right of representation of the petitioner, and made the provision of horizontal reservation for home guards nugatory. There is no ambiguity in the law as declared under Article 141. As such, it is a mandate that all civil and judicial authorities must come in aid of Honorable Supreme Court. The laid down in the said judgment has been violated with impunity by the authority which led to the misutilization of 94 number of vacancies under the UR category with the purpose of wrongful gain. It is a clear malafide exercise of power by the authority as it demolishes the representative participation in a public service, which is a promise of the Constitution. So my humble understanding, Millard, of this, Millard, if 68.92 is well within the parameter, even if I bow down to your lordships, then Millard, the rationale behind such fixation, Millard, then it has to be made with reference to something.
It cannot come, my lord, out of nothing.
That you have not challenged.
My lord.
There is no challenge to the fixation, the marks that it is wrong, you don't say.
My lord,
You say it can't be
no,
done.
I said, my lord, I have two submissions which are not, my lord, mutually destructive. If my first compartment of limb of argument that the cutoff
That is
marks
not
cannot
your
be.
case in the application.
My lord, I tell your lordship, my lord, I am not required to make subject to correction because it is a question of Article 14 arbitrariness, fundamental rights. I am before a highest constitutional court before the state. If your lordship finds that this fixation, I argue this because my entire premise of the submission on the first day, you cannot fix the cutoff.
You cannot, that is your case. So if
Now,
you
my lord, if your lordship says
contend to the
no,
contrary,
if your
then
lordship says no, it can. If your lordship says, if your lordships are not with me, with
why do we don't know?
I don't know. I don't know. I cannot, my lord, I never, my lord.
Even now, we don't know right now.
No, I don't know.
Only after we hear him, we will know.
No, my lord. Your lordships, my lord,
Or
kindly.
maybe later thereafter, we don't.
It's a judicial mind.
Yes.
But I know, my lord, that your lordships are the firm believer of a question that changing judges, my lord, do not change the law. Otherwise, the law becomes uncertain. So that is, my lord, the well settled. So, my lord, I am before a judicial mind. That is why your lordships are so patient. Otherwise, I bow down to your lordship's tolerance. But, my lord, only one thing. I do not know whether it will be at the cost of tiring repetition. But if your lordships say that the fixation of marks, if without any basis, it leads to the path of arbitrariness, Article 14. The moment your lordships hold that is an Article 14, my lord, it is a question of fundamental right.
It is not your case.
My lord, I have
Your
said,
case is it cannot be done. That is
my lord,
the end of the matter.
But the legal issue, it is a legal issue. It is a legal issue. Because
see, in a case, unless whatever you come to the court with, that is the only thing that is to be said.
I am saying it is
all your judgments are also on the same issue.
It is an argument, my lord, from not from the bar or from the record. Governments have not come with a record as to how they have assessed the marks.
They are not called upon.
Because, my
you
lord,
say it can't be done.
No,
if you had said how they have done it, then they may have been required to do that.
The question is, my lord, if it is within their power, then, my lord, how it has been done?
We don't know whether we are required to see that. Your only case is
Now,
that it can't be done.
My submission is twofold, my lord.
But you can't make this submission. This was never your case. How can they now be called upon to answer to something which has not been your case before the tribunal? We are confined to the issue before the tribunal. It cannot be expanded in a writ proceeding.
If it is a question, my lord, if it is a question of law.
No, it is not. It is a question of fact. Which fact you have not disputed?
68.92 are before your lordship.
This fact is not in dispute. You say it is untenable altogether. Not the quantification. You say it cannot be done.
Cannot be done.
Unless you raise an issue regarding the quantification, which you have not done. Where is the question of looking into it?
My lord, I thought, my lord, subject to correction, if I said.
We have understood what you are saying. You are saying that the list was to be operated. All those we merged as per merit, they would ultimately be segregated in UR, and then those who remained, they would come in the respective categories. This is what you are saying. Where is the question of fixing a cutoff marks in between? If we have understood correctly, this is the sum and substance of it.
Submission and petition may kindly be allowed.
Yes. Yes.
May I permit to pray for
how you have fixed this cutoff mark?
kindly see. Kindly see the impugn order.
Impugn order.
Order passed by the Lord of Tribunal.
Yes.
May I permit to read. Applicant has prayed for setting aside the final merit list of provisionally successful candidates. Have you also got it?
Just give us a minute, sir. Yes. The applicant has prayed.
Prayed for setting aside the final merit list of the successful candidate for the post of constables in Kolkata Police. Exemption 22. Submissions of Mr. Odhikari. Granted counsel is that the applicant, despite having scored 65.3 marks, was not selected as unreserved home card category. The applicant believes that among all the unreserved category candidates he had secured highest mark. In this regard, madam, this is very important. He had furnished his representation before the West Program Board and placed for direction upon the respondent authority to consider the same. Madam, after the saying that only my representation should be considered, can you go into the question? I'm putting the question to myself.
can praise.
The applicant believes that among all such and such, in this regard, he had finished a representation before the praise for a direction to the authorities to consider the same. The first line, the applicant has paid for setting aside the final value.
We don't know. This is not the place to go into this. You know very well.
The first paragraph said, Miller, I am asking for, first sentence.
Yes.
That is, Miller, the applicant has praying.
You finish by saying, I have given a representation. And
Miller,
a direction would
Miller,
suffice.
kindly, Miller, this is not a concession on fact. The law.
This is not a question of concession. This is a submission recorded in the court's order which cannot be
I said, Miller,
examined by any other court.
But question here is, Miller, that there are two prayers. Had prayed, these are two prayers tribunal has chosen to
No. There are no.
Yes, the applicant has prayed for setting aside.
Yes.
And ultimately, the learned counsel, the applicant believes that among all such and such, in this
Was your
regard,
prayer, but you believe you have the highest, therefore
he
you
had,
ask them
he
to.
had furnished a representation. The applicant believes that among all such and such, he had furnished such and such and prays for a direction.
Difficult, very difficult, sir.
I will answer to that.
Answer. This is the only issue now.
Now, Miller, the question is
the order is sacrosanct.
The dependency, Miller, they had passed. Now, Miller, the court has granted.
This is on your asking.
That the court had granted leave to file a supplement.
This is on your asking, which asking has not ever been disputed.
I have questioned, Miller, this, but you have a supplementary affidavit.
You may do everything here, but this order cannot be upset in any other forum. You know the law very well.
But Miller, here, Miller, when the court was conscious.
Sorry.
On the day the leave was.
We can't start doing this. We cannot start doing this. A submission and a recording in the court's order, the appellate court or this court exercising judicial review will go into it. Then every case, it becomes meaningless, whatever you say before the forum.
Miller, this was, Miller, I am ultimately, Miller, I am assailing it is true that I am assailing the order, Miller, passed by the authority. But this is during the court.
That's not the point. The point is you asked for this. You did not, you made 7 prayers and you said only the disposal of my representation will suffice. Then where is the question of going into anything else?
But Miller, he says that believes and he had furnished the applicant.
That interpretation,
I put this question, I waive my right to be considered illegally.
We don't know. Your client has accepted it, otherwise he would have filed the appropriate, he would have chosen the appropriate remedy.
The state says, Miller, having secured however, emenda, state council submits that if a direction given to consider the representation, the same will be considered under the rules. Then state also said.
Yes, both of you agreed that only representation was to be disposed of.
Miller, in view of the submission, then court says the chairman. It is not a
concept. Question, this cannot be opened now.
Miller, during the pendency of this writ petition, Miller,
we don't know. Then that is a different issue, sir. We thought that
Pennon has lost his life. I cannot go back to the tribunal during the pendency of the proceeding. I will, Miller, this will be a premature death, Miller, in this long period.
What can be done? This is your lawyer appearing before the tribunal, and you have accepted it. You have not chosen.
It will not be revived.
Your lawyer has said this, sir.
But this is a
this is not a concession on any legal aspect.
I submit with humility. Miller, the tribunal was confronted with, Miller, 4 or 5 prayers in the petition. Now, one of such prayers, Miller, although, Miller, I cannot travel beyond the records. Whatever is there is there. Now the question is between the 2 prayers, one was chosen. Now, Miller,
that we don't know. That we cannot read into the order.
Question is, Miller, during the pendency when this order comes.
That is immaterial. If this few had not asked for this, then of course that
court had granted leave, Miller.
All right, means that very well. We'll consider. Yes.
Another aspect, I am trying to get respect. Paragraph 14 of the written notes of argument. That there is a
Yes, you proceed.
In paragraph 14 of the written notes of argument, page 5, that SC home guard category, the cutoff marks was fixed at 49.42 and SC category fixed at 62.
Page 14.
Page 5, paragraph 14.
Yes.
At SC home
Page
guard.
5, paragraph 14.
Of the written notes of
Where is paragraph 14?
notes of argument filed by Mr. Bose.
Page 5, paragraph 14.
Paragraph 14. And one by us, one by
board.
Mr. Bose.
Oh, you're referring to written arguments filed by them? Yes.
Factual mistake. SC home guard category, the cutoff marks fixed 49.42 and for SC category was fixed at 62.97. It is 62.67.
At?
It should be 62.67.
Or not 97.
97.
That is a typographical mistake.
But another, from even difference in the cutoff for OBC B and OBC home guard category, difference of cutoff is 10.5 is also incorrect. Not applicable. Kindly see our chart. We have 100 over. But kindly see our notes.
They have a, there is one
Page,
big chart also.
note of argument page 7. We have prepared a chart.
Where is that in your written notes?
Here.
Page
On page 7.
7.
OBC B home guard kindly see. Cutoff marks not applicable.
Where are you reading?
But kindly see last column OBC B. Have you also got it left hand side?
Yes.
Then middle portion OBC B, OBC B EC, OBC B home guard. Have you also
Yes.
got it? Third line. Then number of vacancies 12.
Yes.
Effective vacancies 73. Then we have divided. OBC B, home guard not applicable.
Nobody is selected.
Yes.
Yes.
And my friend has said that the gentleman who has been appointed under the home guard, he secured less marks. My lord knows that there is a vertical reservation and horizontal reservation. He is a scheduled caste candidate, and accordingly, according to the cutoff marks, my lord, he came within the zone of consideration because of his scheduled caste candidate. And scheduled caste candidate, my lord, kindly see. Scheduled caste candidate, cutoff marks is C 49.2. 49.42. And he's a general caste candidate. Can I deprive him?
49.42.
49.42. That is that. Kindly see table. Scheduled caste. SC home guard. Number of vacancies 66. Kindly see the right hand side. Cutoff marks 49.42.
Yes. So how is that relevant? Oh, he is claiming inter se evaluation with this person.
He said that in place of him, he should have been given appointment.
No. He has not referred to anyone. We asked him who has got the marks lesser than him. He did not say that. He is only on the cutoff marks cannot be fixed.
And in my serial number, this Pushpendu Midda. His name is Pushpendu Midda, serial number 1409. Page 4 of my written notes of argument. Page 4. Rule 11 of the rules provide that the final merit list of provisionally selected candidates will be prepared on the basis of total mark obtained by the candidates in the written examination and the interview. In the present case, cut-off box score was fixed following the rule 11/22 rules as reported by Commissioner being an unreserved candidate under horizontal reservation. His marks was below 71 officer and 68 point of home guard. The candidate SC home guard was selected under SC home guard category as Procedural was obtained same marks or cut-off marks of SC home guard category fixed by the West Bengal Recruitment Board. Then Malad, kindly see the recruitment rules.
65.8.
Kindly see the recruitment rule. Also, rule 9.
So if OBC is 68.83, then you are these categories reserved has to be above 68.8. Cannot be.
Rule 9, but can you see? Repeated number of candidates will be called for interview in accordance to the merit. The minimum qualifying marks for getting interview be called decided by the board.
Reading it.
Marks obtained in the interview were also taken into account while preparing the
You are reading which provision?
rule 9.
9.
Rule 9.
So the marks will also be taken into account.
Yes.
Yes,
Then,
that is his case also. That is
yes. Can you say rule 11? Preparation of merit list. Final merit list of provisionally selected candidates shall be prepared on the basis of the total marks obtained by the candidates.
correct. Aggregate will be the.
Yeah. And but there is no such provisions in the rules or in the advertisement for fixing a cut-off marks. Cut-off marks to be depends upon the candidates qualified, number of vacancies, and suitable candidates available. That has been decided by a Supreme Court. Kindly see 2007, volume 8 SCC, page 100. Paragraph 10, 14 to 16.
Has anybody obtained
Order?
68.83 in OBC B category? Under OBC B category?
Order OBC?
OBC B category.
B.
OBCB, how many were selected?
Just give it. 68.883.
How many have been selected, sir? Perhaps 71. Sixth column in your chart. Huh? OBCB.
Yes.
71.
Total 73.
No. That is OBCB along with the horizontal reservation. We are talking about OBCB only.
OBCB 71.
71.
That provides in the rules.
So it has to be.
And this has been followed by 100% model roster. Except
out of
physically handicapped candidates.
getting up to 83 vacancies, 70. So therefore, this is the cutoff for unreserved. Category has to be below this. So the next category is the. So it has been kept at 560. In OBCB, 68.8. So it has to be above this. What happens is, that's what I'm doing. Yes. that would have qualified on the basis of merit in this 544. After this 71, the next OBC B would be 68.8.
No, no, no.
With maybe 70. That would then be 70. 69. So last OBC B after taking 71 candidates. Can see that there's no place because he has considered everything. Here has himself has to be yes.
And but this whatever. So for a distribution of seat, not according to the notification issued by the state government. And can you say how this paragraph 8 of the 100% of stuff?
What is that?
That how the vacancies to be distributed.
How what is to be distributed?
Vacancies.
Vacancies.
According to 100.
No, that roster is not in question. That is already prepared. That is not in question.
So my friend said that since he is a scheduled caste candidate as a home guard, he should have not have been given appointment. He should not be given.
No, no, that he has not said.
No, he has said so. If for the first day that gentleman 1409 was the serial number has been appointed as a scheduled caste home guard, and his mark is less, but he has been appointed, but he has got hard mark. He has not been appointed.
Yes.
And now the question is whether we have got any power to fix a cut-off marks after holding the personality test, physical measurement, and interview. There is no provision in the rules for fixing a cut-off mark. But a cut-off marks will be fixed on when? Cut-off mark will be fixed before professional selection measures. That's provided in Rule 11 and 12. Read with the Rule 9.
Yes, 11 and 12.
That means that he was informed, according to my learned friend, that he was not informed nothing. The rule was made available to him. He knows that this is the rule.
Where is the expression cut-off marks used in this?
Cut-off marks need not be expressed.
So that is what he is saying.
But
there is no provision for cut-off.
I have not seen a single judgment that cut-off marks has to be notified. Cut-off marks has
Just now he has given us this division bench. No, only one on cut-off marks. Only one on cut-off marks. The Calcutta judgment.
I'm relying on the Calcutta judgment. But kindly see our on a page.
Oh, Milord, I have forgotten to tell one thing regarding in the mention in the written notes. Division bench judgment which supports my view. The bench comprised of Justice Nishita Matre as a leadership then was, and Milord with sitting with Justice Saubhrata Chakraborty. It supports my view, but against this judgment, Milord, SLP was preferred, and that is still pending.
Oh, this Calcutta judgment.
No, 2016 SCC only.
Yes, yes. The one you have given where cut-off mark has been used, expression cut-off mark has been used.
So kindly see our page 20 of my written notes about the matter. Order dated 5th December 2016, passed by Justice Matre and Justice Saubhrata Chakraborty.
What is the law when there is such a concession and based on concession a matter is disposed of? Then it is open.
Every disposal, when based on a prayer, it is essentially a question of law. Because when the court grants such prayer, because, Milord, I tell you, Lordship, why? Milord, what is the ramification? I put this question to myself when the court and the parties were put to the notice that during the pendency of the writ petition, such exercise has been done by the
No, that we are not on that. Forget about what has happened.
Then
We
you
are-
kindly give me a day's time, my lord.
When
Because I have to cross the hurdle. I cannot waste your lordship's valuable time by showing.
on that we have made a prima facie.
But I am not in a position to satisfy my lord conscience with regard to this particular line.
What is it? You never withdrew that consent.
Question is, my lord,
You
whether
never withdrew the consent.
Why, my lord?
You proceeded further, taking that consent with you. And now, whether you can, if we can permit this, then it will become a
Question is, my lord,
very
special and peculiar circumstances.
no. There is no special and peculiar circumstance.
All right, my lord. Today I am not, my lord, in a position to answer to meet the query of your lordships.
You are knowing the judgment. We are also knowing the judgment.
I cannot match with your lordships, my lord.
No. Maybe the other way around, but
No.
but the point is
Highlighted reservation and vertical reserve are two different things.
no. We are unnecessarily we have
Primary point.
we are required to see this issue first. Otherwise, nothing can be done.
Submission that Justice Matre said, cut off marks not stopping.
That hurdle, unless they cross, it cannot be.
Yes, I have.
The first day you raised an objection that an order has been passed. We did not see that it was on his asking that it has been done. We said
Sorry, but I placed before the rest.
so then that you have pointed out. If it was only a question of passing of an order, then we don't know what we would have done.
Monday, Monday.
Yes, please. We have heard
Only
everything.
one point.
One point. Yes, after some argument.
Please. Item 15.
Lordship, item number.
Appear for the petition.
I appear for the state, your lordship. The reply has been filed just now, your lordship. It has been,
So you'll file another opposition.
no, your lordship. Kindly gives me a day's time, your lordship. I shall come back on Monday with.
Let us start. We'll let us start. Let's see what is the issue.
There.
Yes.
On 9th October 2018, my lord, there was an advertisement, my lord, published by the West Bengal Health Recruitment Board, my lord, to 3 posts, my lord, unreserved 2 and scheduled caste 1. My lord, this was for the post of Inspector of Drugs. Page 37, my lord. Now, my lord, having verified that he possesses the eligibility criteria, that is the petitioner, in clause A of the advertisement, my lord, the petitioner had submitted requisite application in proper form, my lord, within the stipulated time period, and upon filling up all the relevant details which were sought for in the application form. Page 42, my lord, petitioner was shortlisted and called for the document verification cum interview on 30th March 2019. My lord, 37, I place it for your lordship's kind consideration.
Page 39.
37. Millet qualification has been written in 37.
Yes.
First, the relevant rules and necessary particulars are stated in the following paragraphs. A candidate should verify from the notified rules that she is eligible. The condition prescribed cannot be relaxed. The recruitment shall be made by selection, but where a large number of applications are received as a result of the advertisement, the board may, for the purpose of shortlisting, hold a preliminary examination. But no preliminary examination was held. Now, my lord, second qualification, academic and experience. Now, I have submitted at the outset, my lord,
The name of the post is Inspector of Drugs, unreserved to SC1. That my client belongs to unreserved category. Thou, my lord, essential. A degree in pharmacy or pharmaceutical science or medicine with specialization in clinical pharmacology or microbiology from a university established in India by law and shall have undergone practical training in the manufacture of Ayurvedic, including Siddha or Unani drugs as the case may be, or a degree in Ayurvedic or Siddha or Unani degree in Ayurveda pharmacy as the case may be conferred by a university or a state government such and such within the Board of Indian System Medicine recognized by the government for this purpose, or a diploma in Ayurveda, Siddha, Unani system as the case may be granted by a state government or an institution recognized by the government for this purpose, and knowledge of Bengali spoken. So submission of an experience certificate was not one of the essential conditions for consideration. Am I clear to my lords?
Yes.
Now, my lord, it only says in the sixth line, should any of the statements made in the application be subsequently found to be false within the knowledge of the candidates, I do not fall under this category. So, page 38, my lord, I have should any of the statements made in the application be subsequently found to be false within the knowledge. So it doesn't apply to me, but this is the only condition. Kindly comes to page 40 directly, my lord. Distribution of marks for recruitment to the post of Inspector of Drugs, Inspector lying under the Directorate of ISM Drug Control. Marks obtained 10 plus 2, 20. Marks obtained in degree 50. Marks obtained for postgraduate subject 10. Professional experience per 1 year marks each countable up to 5 years, 5 marks. Interview 15. Please note that the candidates must upload scanned photo, signature, candidate certificate, if any, and all the testimonials and experiences scanned copy at the time of filling out the application form. So I am required to submit, my lord, experience certificate in order to obtain, my lord, 5 marks maximum, my lord, for my professional experience per year 1. So if I don't submit, my lord, I lose these 5 marks. Am I clear?
So you are saying even you are claiming something and you don't upload the certificate and support them.
I uploaded, my lord, but they said I did not. That is why my candidature has been cancelled.
So there is a dispute that whether uploaded or
now, my lord, page 41.
So even if it is not uploaded, you say only the marks were to be excluded, not your candidature.
And you are required to, the state is required to intimate me as to what is the actual marks I have obtained out of 95. If 5 marks that is gone. And after the documents verification, I was called for an interview. So it presupposes that the documents were verified. Now, my lord, what the interview letter, page 42, documents verification comes such and such. With reference to our dear candidate, with reference to our advertisement such and such for recruitment to the post of Inspector of Drugs, the government of West Bengal, you are being called for documents verification. You will be allowed to appear in the interview on the same day. You will be allowed to appear at the interview on the same day. That means, my lord, unless I cross this hurdle, my lord, assuming that according to their statement, I was allowed to appear at the interview on the same date. If all the candidates are authentic in West Bengal, the authenticity has not been questioned. In the same day, my documents were verified and I was allowed to appear. Thereafter, page 43, it is a selected candidates, my lord, they were called for. I do not fall within this because my name was not included. Now, my lord, page 45, if your lordships kindly take pain, my lord, to turn page 45, your lordships will be pleased to find that name of the candidates recommended for appointment to 95 posts of senior Ayurvedic medical officer subject to completion of necessary process as per government rules. And my names, Millard, did not appear in this list. I challenge Millard this panel. Now in my reply today, Millard, may I take my lord's kind attention to the opposition first, Millard, page 4. Then I will take my lord's kind attention to my reply. Pursuant to the advertisement, page 4 of the opposition filed by my learned friend's client. Pursuant to the may I start? Please. Sorry. Pursuant to the advertisement, the petitioner, along with the several other applicants, had applied for the post through online portal as indicated in the said advertisement. Subsequently, all the applicants were called for documents verification cum interview on specified dates through memos by the concerned authority. The petitioner was called for an interview cum document verification on 13th March 2019, various attached. It was specifically indicated in such letter that it was compulsory for every candidate to produce physical copies of all verification documents indicated in the letter of verification. It was further indicated the candidate must ensure that he had fulfilled all the conditions of eligibility criteria for the applied post as per the advertisement. Advertisement does not say, Millard, under the column essential qualification that bringing, Millard, the essential certificate which bears, Millard, 5 marks was compulsory or essential. Be that as it may, upon verification of all the documents submitted by the petitioner to the appropriate authority, it was found that application of the petitioner was incomplete due to non-submission of essential qualification certificate, practical training, Ayurvedic science, and the petitioner was not found eligible for the post. So that is the only ground, although I was allowed to appear in the interview. Now, Millard, subsequently, upon completion of the interview, the board recommended 3 candidates. Where is my reply, Millard? My reply, kindly allow me to place. Reply, Millard. Paragraph 7, page 3. 8, Millard, paragraph 8, page 3 of my reply. That with regard to statements and allegation and or statements such and such, allegation, averment is categorically denied and disputed, except for what may be the matters of record. It is denied that upon verification of all the documents submitted by the petitioner to the appropriate authority, it was found that the application of the petitioner was incomplete due to non-submission of essential qualification certificate. The petitioner's candidature was rejected. Till such time when the original application being way number such and such was taken up for consideration, the petitioner had received no intimation and or communication notifying rejection of his candidature due to incomplete application. Moreover, had the application been incomplete, the petitioner could not have obtained the computer-generated acknowledgement slip at page 41 of the writ petition issued from the application portal upon successful completion of the same. It may be that due to some technical glitches, the said acknowledgement slip did not reflect the fact that the petitioner had submitted a compressed PDF file containing all requisite documents, including essential qualification certificate. I categorically submitted, Millard. In the paragraph 9, it is further stated that the marks quoted in paragraph 6H were never disclosed at the time of publication of notice dated 26 July 2019, and in the absence of such disclosure, the petitioner had every right to question as to why seats reserved for general unreserved candidates were filled up by reserved category candidates. For obtaining such disclosure, there was no need for the petitioner to include every other candidate as a party respondent in the original application. Millard, that is my case, and the rules, Millard, 1965 rules, after that whether the amendment has been carried out, I do not know. The rules do not empower that non-submission of such certificate, whether it is entitlement client, assuming not admitting, Millard, I have not given. But I have shown, Millard, from 41, they did not, Millard, say that page 41, which was generated from their own portal, it leaves the room for doubt, not to believe it, Millard. This is also not the case made by the state. If your lordship takes it up Monday, Millard.